Welcome to The Explainer. Today, we're diving into a really fascinating legal mystery. We're going to unpack exactly why the Constitutional Court of South Africa flat out rejected a highly qualified expert organization that honestly just wanted to help out. And you know what makes this so wild? They got rejected even when the state entirely agreed to let them in. It's this incredible story about strict legal rules, procedural fairness, and what actually happens when an outside party tries to crash a high-stakes legal battle.
To solve this procedural puzzle, we've got a clear roadmap. We'll quickly hit the friend of the court, the rules for Amicus Curiae, the court's ultimate discretion, what the ISS proposed, why the court said no, and finally, stacking the legal odds. Basically, we're tracing the strict rules, the historical precedents, and the specific facts of this monumental constitutional judgment. Let's get into it.
Okay, Section 1. The friend of the court. Entering the fray.
So let's first establish who exactly wanted to join this case and what they were actually hoping to do. You've probably heard the Latin term before, right? Amicus Curiae. It literally translates to a friend of the court. Basically, it's an individual or an organization that steps in to help the court out with some unique insights. They aren't a main party, like they're not the prosecution or the defense. Instead, they're allowed in to offer really targeted submissions on the law or the facts. Their whole purpose is to assist the court in a way that, well, the court wouldn't otherwise be assisted. Think of them like a guest expert, stepping in with a fresh, much-needed perspective.
Now, in this specific judgment, the applicant trying to get in was the Institute for Security Studies, or the ISS. They're a really prominent research organization heavily focused on human security in Africa, and they have a massive vested interest in international criminal law. So naturally, they wanted to give the court their expert perspective. To do this, they went to the main parties to ask for permission. On one side, the state gave their written consent. They essentially said, yeah, sure, come on in. But on the flip side, the respondent, Dr. Basson, said no. He declined to consent. And under the rules, because they didn't have unanimous consent from absolutely everyone, the ISS had to apply directly to the Chief Justice to get admitted.
Which brings us to Section 2, Rules for Amicus Curiae, the entry requirements. See, getting into the highest court in the land requires way more than just, a general interest in a topic or a noble mission. According to Subrule 10(6)(c) of the Constitutional Court, an amicus applicant has to jump through a very specific set of hoops. They've got to describe their interest in the case, identify their position, set out their submissions, prove they're relevant, and show exactly how they'll be useful. But here is the absolute key to this entire case. They must prove their submissions are different from what the other parties are saying. Rule 10 basically says you have to bring something genuinely new to the table. It's exactly like bringing a dish to a potluck dinner. If someone else is already bringing a massive bowl of potato salad, the host does not need you bringing another potato salad, no matter how amazing your recipe is. You have to bring something new.
Moving on to Section 3. The court's ultimate discretion. The gatekeeper.
Now you might be thinking, hey, they have the state's written consent, and they're a respected NGO. Surely they're getting in, right? Well, no. The court holds the ultimate keys to the door, and this brings up an established precedent. Look at this powerful quote from an earlier case called Foes versus Minister of Safety and Security. The court explicitly pointed out that just because you have the written consent of all the parties, it doesn't excuse you from those underlying principles of being useful and different, and it definitely doesn't diminish the court's control over who actually gets to participate. Basically, consent does not mean automatic admission. The Chief Justice and the court are the ultimate gatekeepers. They have a strict duty to make sure those core principles are met, otherwise they just can't let you in. They have to fiercely guard the court's time.
Let's look at Section 4, what the ISS proposed, the NGO's argument.
So what did the ISS actually plan to present to the Constitutional Court? What was their proposed dish for this legal potluck? Well, they laid out a really serious, heavy academic agenda. They wanted to provide an expert look at the history of individual criminal responsibility under international law. They also wanted to outline the duty of all states to try or extradite people for crimes against humanity and war crimes. On top of that, they planned to detail the legal consequences if South Africa failed to prosecute those crimes. And lastly, they wanted to dive into the extraterritorial effect of amnesties, specifically pointing to amnesties granted back in the day by the Administrator General of Namibia.
I mean, it all sounds incredibly relevant and super academic, right? But think back to those strict rules we just talked about. The absolute crucial question here is, did these proposed topics actually meet the strict Rule 10 criteria? Were they truly different and useful compared to what was already sitting on the judge's desk?
This brings us to Section 5. Why the court said no, the plot twist.
To figure out exactly why the ISS got rejected, we have to look really closely at the massive pile of paperwork the state had already handed in. When the judges measured the ISS application against the state's existing written arguments, oh boy, they found a towering stack of historical research already on the record. It turns out the state had already submitted 60 pages exhaustively covering the exact same international legal history. I'm talking tracing customary international crimes from the 1907 Hague Convention, all the way through World War I and II, the Nuremberg Principles of 1950, right up to the 1998 Rome Statute. The state had even explicitly covered the extraterritorial effect of those exact same Namibian amnesties.
Well, let's actually put them side by side because it's pretty wild to see. Over here on the left, you've got the ISS wanting to address crimes against humanity, war crimes, and amnesties. But then, on the right, the state's massive 60-page submission already covers crimes against humanity, war crimes, amnesties, plus international treaties and jurisprudence. The ISS's proposed potluck dish was a total duplicate. The central issues they wanted to tackle were already deeply covered by the state. Because they literally couldn't offer any new contentions, they fundamentally failed that crucial Rule 10 test. The court even mentioned that the few other tiny points the ISS raised were just relatively tangential.
Now for our final piece, Section 6, Stacking the Legal Odds, the Criminal Caveat.
But there's actually a lot more to this ruling than just, hey, we already have this paperwork. There is a really profound legal philosophy at play here regarding fairness, especially when we're dealing with high-stakes criminal trials. The court stressed that in complex criminal appeals, an accused person is absolutely entitled to a well-defined case coming directly from the state. Courts have to be hyper-aware not to allow an amicus to unfairly stack the odds against the accused. Think about it. If an outside friend comes in purely to strengthen the prosecution's case against someone who is already facing a massive legal burden, the court has to tap the brakes. It's driven by the principle of equality of arms, basically making sure there's a fair fight in the courtroom, where the defense doesn't suddenly get ambushed by extra prosecutors sneaking in through the back door.
So what's the big takeaway here? The ISS was denied, but not because their research was bad or because their mission wasn't important. They were denied to strictly preserve procedural fairness and that equality of arms we just talked about. The court absolutely prioritizes those vital principles over just having a huge volume of arguments. It was a totally essential move to avoid bogging down the process with redundant points and to make sure the accused didn't have to fight a completely unnecessary two-front legal war. Under these specific circumstances, the court decided it simply wasn't in the interests of justice to let them in.
This ruling leaves us with a really fascinating final thought to chew on. Does true justice depend on letting every single willing expert and voice speak their mind in the courtroom? Or does it depend on the strict, sometimes really rigid discipline of maintaining a perfectly balanced scale? By strictly enforcing Rule 10 and keeping the ISS out, the court made sure the scales didn't tip unfairly, proving that sometimes, for sure, the absolute best way to be a friend to the court is knowing when your voice isn't the one that needs to be heard right then. Thank you so much for joining me for this explainer. I really hope it gave you a clear look at how our highest courts balance information, fairness, and the strict rules of the game.